Courtroom chaos. The judges blocked the subpoenas of Justin Baldoni's lawyer as Blake Lively files for sanctions. We got Ron Zambrano here to explain it all.
Courtroom chaos erupts as a federal judge delivers a stunning ruling that could reshape the entire Blake Lively versus Justin Baldoni legal war. In a dramatic turn of events, the court has blocked Blake Lively's aggressive subpoena attempts targeting Baldoni's legal team, but that's just the beginning of this explosive story.
The judge has now blocked Blake Lively's subpoenas of Justin Baldoni's legal team. I mean, this was expected. It's not pretty typical to be able to get stuff from the lawyer and his clients. That's privilege.
Because while Lively celebrates what appears to be a partial victory, she's simultaneously launching a nuclear option, filing for sanctions against Baldoni's high-profile attorney, Bryan Freedman. The question everyone's asking tonight, could this backfire spectacularly and land her legal team in hot water instead? What you're about to discover will shock you.
Beyond that, specific communications will not be handed over, correct? Was this the right verdict? And can you sort of explain to the audience what this all means?
Yeah, so the judge took a very tempered view and I think specific view as to what each individual request is asking for, splitting them into three categories. So
strategic missteps, leaked transcripts, and courtroom blunders that could determine whether justice prevails or if Hollywood's power players can manipulate the system. Was this all a carefully calculated setup, or is someone about to learn a very expensive lesson about crossing the line in federal court? The bombshell ruling from Judge Lewis Lyman has sent shockwaves through both legal camps, but the devil is in the details, and those details reveal a far more complex picture than either side wants you to see.
The judge is taking the attorney's word for it, Liner's word for it, like there are no responsive documents, and the judge goes, okay, until you tell me they're lying, I have to take their word for it, let's move on. I think that's very, very, astute way of doing it.
Here's what actually happened. Blake Lively's legal team launched an unprecedented attack on the heart of attorney-client privilege itself. They didn't just want documents. They wanted to crack open the entire strategic playbook of Justin Baldoni's defense team. Their subpoenas targeted Bryan Freedman's law firm demanding access to privileged attorney-client communications, internal strategy documents, correspondence with content creators, and essentially any communication that could reveal how Baldoni's team has been defending this case.
But then regarding specific communications and the other sort of requests for productions, that's where he said no.
Yeah, so in the other two, he said no. And again, he took a very, very specific category by category analysis. So for the second one, had to do with documents between
communications and concerning content and more media generally.
This wasn't a fishing expedition. This was dynamite fishing. Lively's attorneys were asking the court to blow up one of the most fundamental protections in the legal system, the sacred bond between lawyer and client. Judge Lyman saw exactly what was happening and responded with surgical precision that reveals just how experienced he is with these high-stakes celebrity battles. Instead of issuing a blanket ruling, he dissected Lively's subpoena requests like a master surgeon, dividing them into three distinct categories, each with different legal implications and strategic consequences.
As if you have more to tell me, listen, we've tried everything under the sun to get this another way and it's not working, we need to come back, then if the judge is satisfied with those efforts that don't bring to fruition, then he will reconsider this, which I thought was very, very interesting.
The first category involved general documents related to content creators that Freedman's firm represents outside of this specific lawsuit. Here's where things get fascinating. In open court, Freedman's team made what could be seen as either a brilliant strategic move or a devastating tactical error. They stated unequivocally that no documents exist regarding the specific content creators that Lively is concerned about. Think about the implications of this admission. Either Freedman's team is telling the absolute truth, and there really is no coordinated campaign with content creators, or they're playing an incredibly dangerous game by making false statements to a federal judge. There's no middle ground here.
So is it not okay for Freedman's team to be out there speaking to press or creators to say, here's our official statement, or here's the evidence that dropped that's part of our legal documents? Where is the line as to what's allowed and what's retaliation in your mind?
That's a great point. So under the litigation privilege that exists in every state, California and New York, things that anybody say connected to what's called a pending judicial proceeding like this is privileged under the litigation privilege from, suing, because that would be a suppression of our ability to bring grievances to the court.
Judge Lyman essentially responded, "If these documents don't exist, then no harm, no foul." He granted protection for unrelated content creator relationships while simultaneously denying the request for documents that supposedly don't exist anyway. It was a masterclass in judicial efficiency that managed to protect legitimate attorney-client relationships while calling everyone's bluff. But here's where the ruling gets truly explosive, and where Bryan Freedman might have made his first major strategic miscalculation. For the second and third categories of requests, which involved specific communications between Freedman and media outlets, plus any documents related to media strategy and public relations campaigns, Judge Lyman delivered a resounding and unequivocal no.
Clear, like he's allowed to speak to the press about the case. That's because that's what's weirdly being, I feel like, spun in the narrative of Blake, is that any communication Wayfarer parties, anybody, whatever them had with press sort of defending themselves with statements is somehow part of the retaliations campaign or ongoing smear campaign. And you're legal. That's not the case. They're allowed to defend themselves.
Yeah, they're allowed to defend themselves. They're allowed to make statements about defending themselves. That's absolutely above board. That's 100% above water.
The judge didn't just cite attorney-client privilege. He went further, noting that these requests were overly burdensome and potentially violated established legal protections. But here's the part that should terrify Lively's legal team. He specifically mentioned that there seemed to be a disconnect between their original complaint and these new discovery demands. In judicial language, that's basically the judge saying, "You're changing your story, and I've noticed." However, and this is the detail that changes everything, Judge Lyman used the phrase "without prejudice." This isn't just legal terminology, it's a strategic roadmap. What the judge is essentially telling Lively's team is, "I'm not shutting this door forever, but you're going about this completely wrong."
So is there a part of this where they've gone too far? Could these sanctions be actually, given?
So it depends what the judge is going to cling on to, is what is the conduct that's violating, what we call violative conduct that empowers the judge to sanction anybody, right?
The judge made it crystal clear. If you want this information, find a less intrusive way to get it. Talk to the content creators directly. Subpoena them instead of going after the attorney. Use traditional discovery methods before you try to blow up attorney-client privilege. This ruling reveals something absolutely fascinating about judicial thinking in the digital age. Courts want to protect attorney-client privilege while still allowing legitimate discovery, but they're not going to let parties use modern media warfare as an excuse to destroy fundamental legal protections. The judge is essentially saying, just because this case involves social media and content creators doesn't mean we're throwing out centuries of legal precedent. But was this really a win for Baldoni's team? The answer is far more complicated than either side wants to admit. Yes, they avoided the immediate threat of having their privileged communications exposed. But they also made several admissions under oath that could come back to haunt them. Meanwhile, Blake Lively's team learned something crucial about Judge Lyman's approach to this case. He's not going to be bullied or manipulated by celebrity status or media pressure. He's going to follow established legal procedures and precedents, regardless of how famous the parties involved might be. The real question becomes, why did Lively's team choose this approach in the first place? Did they genuinely believe they could convince a federal judge to ignore attorney-client privilege? Or was this entire subpoena strategy designed to fail publicly and create ammunition for their sanctions motion? Because while Baldoni's team celebrated avoiding the subpoenas, Bryan Freedman's conduct outside the courtroom was about to become the center of an even bigger controversy. Let's rewind for a second and understand how we got to this explosive moment. This legal battle began when Blake Lively filed a complaint with the California Civil Rights Department, alleging sexual harassment and a coordinated smear campaign against her during and after the filming of It Ends With Us. That complaint contained detailed evidence and personal communications, material that statements must be connected to the legal proceeding and serve a legitimate purpose in the litigation. Bryan Freedman's media appearances defending Baldoni likely fall within acceptable bounds. Attorneys have the right to make public statements about their cases and defend their clients' reputations. The key question is whether any private communications between Freedman and content creators crossed ethical lines. Blake Lively's team is essentially arguing that Freedman orchestrated a coordinated campaign using content creators to amplify negative narratives about her. They want to prove there was a secret strategy involving specific talking points and coordinated messaging. In simple terms, this means they're trying to show the difference between legitimate defense and orchestrated retaliation. If they can prove Freedman was telling content creators exactly what to say and when to say it, that could constitute improper conduct. But here's the strategic problem for Lively's team. They chose the most difficult path to prove their case. Instead of directly subpoenaing content creators who don't have attorney-client privilege protection, they went after the lawyer first. The judge essentially told them, "You're doing this backwards." This tactical error suggests either overconfidence or a fundamental misunderstanding of legal privilege protections. It's a mistake that could cost them credibility with the court. When filing documents with the court, Freedman's team attached an entire deposition transcript instead of just the relevant excerpts they needed to support their argument. Legal experts are calling this a massive blunder that violates standard litigation practices. Here's why this matters. Deposition transcripts contain sensitive information, personal details, and strategic insights that should remain confidential until properly redacted and presented. By filing the entire transcript, Freedman potentially exposed privileged information and gave the public access to far more details than necessary. Blake Lively's team immediately pounced on this mistake, using it as the foundation for their sanctions motion. They're arguing that Freedman deliberately leaked sensitive information to influence public opinion and potential jurors. But there's a deeper issue here that reveals the high-stakes nature of this case. The transcript allegedly contains information about who was present during depositions, what was discussed, and strategic details about both sides' cases. This information is now part of the public record, even if redacted. The sanctions motion paints a picture of an attorney who has repeatedly pushed ethical boundaries. Lively's team points to previous incidents, including a letter that was struck from the record for containing inappropriate information about Taylor Swift and other irrelevant details. They're also challenging specific quotes and statements attributed to Freedman in media interviews, claiming he made inflammatory comments designed to prejudice potential jurors. However, some of these allegations appear to be misattributed. Statements that were actually made by media personalities like Megyn Kelly are being blamed on Freedman. This pattern suggests that both sides are engaged in narrative warfare that extends far beyond the courtroom. Each side is trying to control public perception while simultaneously fighting the legal battle. The potential consequences are severe. If Judge Lyman determines that Freedman violated court rules or ethical standards, he could face monetary sanctions, restrictions on his ability to file documents, or even more serious disciplinary action. The sanctions motion represents a pivotal moment that could determine the trajectory of this entire case. But what are the realistic chances that Bryan Freedman faces serious consequences? Legal experts suggest that judges typically start with modest monetary sanctions for first-time procedural violations, perhaps $4,000 to $5,000. It's designed to send a message without crippling the attorney's ability to represent their client. However, this isn't Freedman's first alleged misstep. The previous incident involving the Taylor Swift letter that was struck from the record establishes a pattern of pushing boundaries. Judges don't like patterns of problematic behavior, especially when they've already issued warnings. The critical factor will be Judge Lyman's determination about intent. Was the full transcript filing an honest mistake, or was it a deliberate attempt to leak information into the public domain? If the court believes it was intentional, the consequences could be much more severe than monetary sanctions. The judge could impose what are called evidentiary sanctions or issue sanctions, essentially preventing Freedman's team from presenting certain evidence or arguments. In extreme cases, courts can even dismiss claims or defenses entirely. But there's another layer to consider: the court of public opinion. By filing for sanctions, Blake Lively's team is essentially arguing that they're the victims of an unethical smear campaign orchestrated by opposing counsel. This narrative positions them as the party fighting fairly, while their opponents break the rules. However, this strategy carries risks. If the sanctions motion fails or appears frivolous, it could backfire and make Lively's team appear overly aggressive or vindictive. Judges don't appreciate frivolous sanctions motions, which can result in counter-sanctions against the filing party. The timing of this motion is also strategically significant. It comes immediately after the subpoena ruling, which suggests Lively's team is trying to maintain momentum and pressure after a mixed result on their discovery requests. This case raises fundamental questions about how the legal system handles celebrity disputes and whether famous plaintiffs receive different treatment than ordinary citizens. Blake Lively's initial decision to file a public civil rights department complaint, complete with detailed evidence and personal communications, was highly unusual. Most employment disputes are handled privately through confidential settlements or sealed court proceedings. By making her allegations public from the beginning, Lively essentially forced this case into the spotlight and created the media circus that now surrounds every filing and ruling. This tactical choice gave her control over the initial narrative, but also opened the door for the kind of public relations warfare we're witnessing. Justin Baldoni's response, hiring a high-profile media-savvy attorney and fighting back publicly, represents the natural evolution of celebrity legal disputes in the social media age. Both sides recognize that public perception can be as important as courtroom victories. But this approach creates new ethical challenges for the legal system. When attorneys become media personalities and court filings become public relations documents, traditional boundaries between legal advocacy and public relations work become blurred. The broader implications extend beyond this case. If Lively succeeds in establishing that aggressive public defense constitutes improper retaliation, it could create a chilling effect on how attorneys defend their clients in high-profile cases. Conversely, if Baldoni's team prevails in arguing that their public statements are protected litigation privilege, it could establish broader protections for attorneys who engage in media advocacy. The entertainment industry is watching closely because this case could set precedents for how sexual harassment allegations, defamation claims, and media strategy intersect in the legal system. As this legal drama continues to unfold, several critical developments will determine the ultimate outcome and broader implications. Judge Lyman's ruling on the sanctions motion will be the next major inflection point. If he sides with Blake Lively and imposes meaningful sanctions on Bryan Freedman, it will signal that courts are willing to police attorney conduct in high-profile cases more aggressively. However, if the sanctions motion fails, it could embolden Baldoni's team to pursue even more aggressive tactics and potentially file counter-sanctions against Lively's attorneys for frivolous motions. The discovery process will ultimately determine which side has stronger evidence. Lively's team still has options for obtaining the communications they want. They can subpoena content creators directly, pursue other avenues for evidence gathering, and continue building their case through traditional litigation channels. Meanwhile, Baldoni's team will likely file their own motions challenging the underlying legal theories in Lively's case. They may argue that her retaliation claims are barred by litigation privilege and First Amendment protections. The financial stakes continue to escalate with each filing. Both sides are reportedly spending enormous sums on legal fees, suggesting that neither is prepared to back down or seek early settlement. Perhaps most significantly, this case is becoming a referendum on power dynamics in Hollywood and whether the legal system can adequately address complex disputes involving celebrity status, media manipulation, and competing narratives about sexual harassment and defamation. The outcome will likely influence how future celebrity legal disputes are handled and could establish new boundaries for attorney conduct in high-profile litigation. The Blake Lively versus Justin Baldoni legal war has evolved into something far more significant than a typical Hollywood dispute. It's become a battleground for fundamental questions about legal ethics, celebrity justice, and the intersection of litigation and public relations in the digital age. While Judge Lyman blocked the attorney subpoenas, the sanctions motion represents the real test of whether aggressive legal advocacy crosses ethical lines. Bryan Freedman's pattern of controversial filings and media statements has put him in a precarious position where one more misstep could have serious professional consequences. Blake Lively's strategic decision to fight publicly from the beginning has created opportunities and risks that will ultimately determine whether she achieves justice or faces a devastating legal defeat. The entertainment industry, legal profession, and public are all watching to see whether the system can handle celebrity disputes fairly and whether truth ultimately prevails over narrative manipulation. And if this case moves forward to trial, it could expose everything about how power, celebrity status, and media strategy intersect with the pursuit of justice in America. What do you think? Is Bryan Freedman crossing ethical lines? Or is Blake Lively trying to weaponize the court system to silence legitimate defense? Could these sanctions backfire and damage her credibility with the judge? Drop your take in the comments below, and let us know which side you think is winning this high-stakes legal chess match. Stay tuned, because this story is far from over, and the next ruling could change everything.